Assalamualaikum warahmatullahi wabarakatuh, and hi everyone. So it's supposed to be our fourth lecture. I'll be sharing with you on contents of contract. Okay. Okay. What is it in contracts, right? I take this from internet, yeah, construction contract. Okay, this is an example, a sample of contract, right? In the contract we have terms. So now we go for the terms of the contract, right? The simplest contract, you see, I put it here. Only the most simplest contract consists of a single promise or undertaking on both sides, right? Most cases, the contract is composed of a number of contractual terms. You can have a look at your, are you taking PTPTN? If you are taking PTPTN or scholarship, you can have a look at the terms of the contract, right? When you sign PTPTN contract, you agree with all the terms in the contract, okay? So you see how many contracts, how many terms are in the contract. Okay, now all the terms, all right, all the terms can be divided into terms and representation. Okay, not every single terms in the contract are important, the integral part of the contract, the most important part of the contract. Only some are the real terms of the contract. Okay, now have a look at your own contract. Go, take it and have a look at it and see the terms of the contracts. Okay, so now in this lecture we'll see the content of contracts. You see, have you got your PTPTN or your loan contract? If you don't have any loan, your parents are paying for it, very good. Try to get any contract. For example, your sale and purchase agreement of the house where you're staying, or the rental contract, you know, if you are renting the contract, the rental contract, okay, any contract. We want to see the distinction between terms and representation, right? Before entering a contract, of course, the parties would negotiate, right? That leads to the conclusion of the contract. First, for example, rental. You negotiate first, all right? You see the rental, monthly rental, how much is it? What do the owner of the house offer you, all right? Is it full furnished or part furnished? You know, that kind of offer made by the owner of the house. So now, right, and after you see that, you negotiate the price. Okay, can the owner reduce? Of course, you never negotiate asking the owner to increase, isn't it? So you negotiate if the owner can reduce or the owner can maintain the price, the rental price, but add more value by adding more furnitures in the house, you know, or put AC, air conditioning in the house, you see. All this negotiation. But for your PTPTN, definitely you cannot negotiate. If you agreeable to take the money, agreeable to all the terms, the money will be given to you. If you're not agreeable, then PTPTN will not negotiate with you the terms. But some other contracts, okay, entered by parties are negotiable, right? Now, when do we try to make distinction between term and representation? Why do we want to know this is the term and this is a representation, or this clause that you are reading are only representation, and this is the most important clause, which are the terms, you see? So when do we do this? When we have dispute, right? When we have dispute, something happened, you know, we bring this matter to court. The court need to decide whether this is a statement of assurance that form part of the contract, or it was merely a presentation or inducement. Okay, a representation or inducement form part of the contract. What does it mean? For example, rental contract. Okay, how many months, how much to pay, This is the most important part. How long you can stay for 1 year, for example, 200 per month. Alright, this is the integral part of the contract. Merely representation, they will put like you cannot draw something on the wall. Okay, when the owner give you the house has just been painted, so you have to return back the clean house without making any destruction to the wall, for example, right? The owner say, okay, we have light, we put wiring, you know, this thing just to induce you to enter into the contract. When you say, oh, they have fan, okay, the wiring is okay, it induces you, isn't it? Okay. A representation is a statement of fact made by one party, the representer, which induce the other representee to enter into the contract. If it turns out to be incorrect, the innocent party may sue for misrepresentation. Okay? Distinction between terms and representations. So now we want to see the difference. What does it mean by terms? So what is term? What is representation? Terms. A provision of contract which states or makes explicit an obligation or set of obligation imposed under the contract on one or more of the parties to the contract. Okay? Term is the clauses that mention the obligation of the parties imposed under the contract. For example, rental. Okay, owner give you house, you stay 1 year. That's the obligation of owner. Something wrong, owner fix. And you pay monthly without any default. If you default, you have to go out from the house. This is the integral part. Representation. A mere statement or assertion made before or at the time of the contract on some matter or circumstances relating to the contract. Representation, for example, the owner said, look, this house is very near to UPM, you know, this area is green area, very quiet, very nice. The representation basically induce you to enter into the contract. Okay, so this is the distinction between terms and representation. We will talk more later. Types of terms. We have implied terms, express term, and also and standard terms. Okay, implied term actually did not expressly mention in the contract, but if something happened, the court will imply, all right, where necessary to implement the parties' presumed intention. The court will imply that this is the term, right? Express term, the clauses that clearly state, all right. The obligation of the parties, for example. Okay. Express terms are the core terms of the contract between the parties. Okay. Standard terms, standardized terms are those set by one party and offered to the other on all nothing basis. The adhering parties does not have the option to negotiate for different terms. Okay. Standard term means all agreement has standards. Time is of essence, which means time is very important. So you need to pay the rental on time. Every single agreement have these standard terms. Time is of essence. For example, any term, rental term, sale and purchase term, you know, your PTPTN terms. Okay, this is standard terms. Effect of breach of term of the contract and mere representation. What are the effects? If you breach term, what happened? If you breach mere representation, what happened? Okay. When a term is breached, the injured party can sue for breach of contract, claim for the contract to be cancelled, ask damages, and request specific performance. Okay. Right, the injured party can do this. You sign sale and purchase agreement, or let's say rental. I keep talking about rental, right? Rental terms, all right? And then you sign agreement to rent a house, a condo, right? However, when you see it's not condominium, there's no swimming pool. This is the main agreement, integral part of the agreement. Okay, the location you want. Okay, so this is the integral part of the agreement. It's just a mere flat. So you can sue for breach of contract when the term is breached, alright? Or you can cancel or ask damages. Okay. And when a mere representation is breached, okay? When this misrepresentation or mere representation is breached, the injured party cannot sue for breach of contract. For example, the owner promise you, I give you big fridge. You want big fridge, I give you big fridge. Alright? However, when you start to pay rental, you go in, you see, oh my god, it is very small fridge. Okay, this is not the integral part. Alright, so this is misrepresentation. Okay, the injured party cannot sue for breach of contract because misstatement is not integral part of the contract. Okay, then the contract is not broken. Although the representation proved to be untrue, the contract is still maintained. Your rental contract still maintained even though the fridge is small. So you cannot repudiate the contract. Okay. You cannot sue for the breach of contract, right? If the term is breached, then you can sue for breach of contract. Express term and implied term. Express term, those which are expressly agreed by the parties as term of the contract, like how many months of rental, how much to pay, what date to pay. Implied term, not expressly mentioned. If something happened and then the court will imply, right? You see, by the court, but are to be implied by the court or by custom or trade or by statute, right? Implied term, for example, you signed into an agreement. The agreement did not mention something on tax, how to pay, how much to pay, but it is upon the parties to pay tax. Right? When there's any issue, the court will look at this or the custom will look at this and they imply that you have to pay the tax. Okay, even though in the agreement there's no clause mentioned that you have to pay tax, parties have to pay tax. It's not mentioned that. But when you sign such an agreement involving tax, of course you have to pay tax. Impliedly there is obligation for you to pay tax. I hope you understand this. Do ask question in our WhatsApp or Putra Blast if you don't understand this. Now, express terms. Express term can be divided into two: conditions and warranties. Right? Something which is mentioned clearly, we can divide into two, that is condition and warranties. Okay. Because every single clause, every single term in the contract, we need to know the importance of the terms and the effect of the terms. Okay? Because when you see your contract, you see that there are various statements and promises on both sides. Alright? So each terms actually differ in importance. Okay? Has its own importance. You look at my slides. The parties may regard some of these as vital, others as subsidiary to the main purpose of the contract. So when you look at it, you can see this is the vitals part. Okay, some of the terms are vitals and some are just subsidiary to the main purpose of the contract. For this reason, that's why we classify the terms into two different classes, that is conditions and warranties. What are conditions? What does it mean? And what are warranties? Okay. Condition. Condition is of primary concern of the contract. Okay. And warranty is a secondary concern. Alright. Condition. If you breach condition, you can repudiate it. The contract can be repudiated. You can repudiate the contract. If you breach, the other party will repudiate, not you. Right. Warranty. Breach means there is only a claim for damages. Okay. For example, there's a misrepresentation. They said they warrant you, they give warranty, I give you a fridge, and suddenly they give very small fridge instead of the big one that you asked for. So the breach, when this is a breach also, okay, so you can claim for damages. All right. And the third point for condition, all right, condition can be treated as warranties, and warranty cannot be treated as condition. See, condition can be implied, warranty is usually only express. Okay, condition is the primary concern. All right, sometimes in certain agreement, even though it's a primary concern, you can treat it as warranty. Condition may be a warranty, but warranty is a secondary concern. Secondary concern can never be treated as condition, as the primary concern. Okay. So to make us understand better, okay, we'll see here that if the parties regard the term as essential, it is condition. All right, condition is very essential. All right. Basically, a condition is a statement of fact or promise which form an essential term. As I said, condition is the primary concern. Condition is the main part of the agreement. Okay, the main part of the agreement. That's why breach of condition, you can go and sue and you can cancel the contract, because that's the main part. When the main part is missing, what else left in the agreement? Why do you want to proceed with the agreement? The main part is not there. That's why condition is the main part of the agreement. Okay. If the party do not regard the term as essential but as subsidiary or collateral, this is warranty. Okay. Warranty can be express or implied statement, express or implied statement, which the parties undertake as part of contract, but only collateral. We have to remember that warranty is only subsidiary or collateral to the main purpose. Okay, the main purpose to rent a house, right? The subsidiary is you want furniture in the house, all right, and you want fridge, all right, and they give fridge but small fridge. So breach of warranty, the secondary, the collateral of the main purpose. Okay, so you can sue for damages. You cannot repudiate the contract. Effect. Okay, effect of breach of condition and a breach of warranty. Breach of condition. Breach of condition, you see, entitle the innocent party to treat himself as discharged from further performance of the contract. When he promised to rent the house but failed to give you the key on the date he promised, okay, after you sign the agreement, and even you wait for 1 or 2 weeks, still he failed to do that, you are the innocent party, all right, and he failed to do his obligation, the most important part of the agreement, that is to give you the key. So this is the breach of condition. When breach of condition, you as innocent party, you can discharge yourself from further performance of the contract. You don't have to wait for him to rent his house anymore. Okay, you can discharge yourself, right? You can cancel the contract now, okay, because he failed to perform his the most important part of the agreement, the condition. Okay, that's a breach of condition. Okay, and if it caused loss to you, because you wait for him 1 day, you wait for him until 7 days, until 1 week, he still failed to give you the key, and you cannot enter the house, and what happened? You have to go and rent a hotel nearby UPM. You have to pay the hotel. It caused you loss. You suffered loss. So it's not just you can cancel the contract because breach of condition. You can also claim for damages for the loss, for the money that you paid to the hotel. Okay, that is breach of condition. Breach of warranties entitles the innocent party to claim damages only. As I said, the fridge is small, you can go and claim damages from him. okay? But you cannot cancel the contract. You cannot simply cancel the rental contract because the fridge is small, but you can ask him, I will go to court and ask for damages, or you can change the fridge now or do something, but you cannot cancel the contract. Implied terms, right? A contract may be subject to certain terms which are not expressed, included in the contract, okay? In other words, the law will imply into a contract terms which the parties have not themselves expressly insert. You might not insert certain things in the contract, but when you have dispute, you go to court. The court will look at both intention and the court imply some terms that you did not expressly mention in your contract, okay? For example, right, when you enter into contract to purchase good or service, for example, right, purchase good or service, right, of course, right, the purpose you are purchasing, you are buying, or you are taking the service so that you can get good service, you can get good product, okay. The contract terms is implied, right, even when there is no written or oral contract about this. So the court will imply this, right? This is implied terms. Terms implied by the court. In certain circumstances, the court implied terms in a contract based on the intention of the parties. For example, to give business efficacy, right? Sometimes you see, in contract, maybe because of forgetfulness or bad drafting, or the lawyer or the person who actually in charge with drafting the agreement is very new, he has no knowledge, not much knowledge, or the person has lack of experience, okay, he failed to incorporate certain terms in the contract. All right, if they read carefully, they would say, oh my god, we forgot this term, this is very important, it should be inserted so that the contract is complete. For example, an agreement entered between two parties, but the drafter forgot to put terms on how to cancel or complete the contract. How? The completion of contract. Completion of contract is one of the most important terms in a contract. So the drafter forgot, right? So now they don't have completion part of the contract. So in such cases, the court may, in order to give business efficacy to the transaction, imply such terms as are necessary to effect that result. So when they don't know what to do, how can we actually complete this according to the agreement we signed? They can go to court. The court will give some terms, the court will imply and give such terms which is necessary to make sure that they can complete the contract. Okay, to see how court actually implied terms, okay, court implied term, we will refer to the case of the MUCOP 1889, right? Basically, in this case, a ship was damaged at the defendant jetty, right? So now, the claimant want to claim for damages, right? You see why? Because the claimant moored his ship at the defendant wharf on the river Thames. Okay, the river Thames is a tidal river, and at times when the tide went up, the ship would come into contact with the river bed. So now it depends on the water, on the tide. Okay, so air pasang yang surut, so that it depends on the tide. So the ship in this case became damaged due to the uneven surface and rocks on the river bed, right? So the claimant now sought damages from the defendant, Right. However, the defendant argued that the defendant said, look, we never deal with this in agreement. I never give you warranty under condition of the riverbed. So you cannot claim damages. This is not part of our terms. Okay. So the issue here is was there any express term? No, definitely there was no express term. So is there can the court actually imply warranty that the space was safe place for the ship? Okay, in this case. Okay, the issue is whether the court can actually imply warranty that the space was a safe place for the ship, right? So in this case, the court held that the ship owner the ship owners were successful in their claim. Okay, the court actually allowed the ship owner claims. The court allowed the claimant damages claim from the defendant. Okay, because the court in the judgment of the court, it was stated that the whole purpose of the contract was to use the jetty, and the jetty could not be used without the vessel grounding. Right. The wharf fingers must therefore be deemed to have impliedly warranted they had taken reasonable steps to ensure the vessel could safely ground without suffering damage. So the court actually impliedly said that there is implied term in the agreement that the defendant, okay, must actually warranted the claimant that the vessel, whatever vessel that comes to use the wharf, okay, including the claimant ships, okay, they should warrant that the ship will be fine, will not suffer any damage. Even though it's not mentioned, there's no term mentioned that the defendant warrant the claimant ships will be safe from damage using the wharf, right? Nothing mentioned, not expressly mentioned. The court actually implied these terms, right? The court implied this term. This is what it means by implied terms. Now we go for exemption clause. In certain agreement, we do have exemption clause, all right? Exemption clauses in standard form of contract, okay. You see, we have many standard form of contract, right? If you go to buy flight tickets, ship, aeroplane, I said here, train, you know, or buy a computer, all right? Or your rental agreement. Compare your rental agreement with your friends. You see, most of the agreement are similar, right? And they are exemption clause for in this standard form of contracts, right? There are exemption clauses, right? Mean by exemption clauses? Exemption clauses actually means exempt the person from liability. Exempt the person from liability, certain liability. All right. So this is what we call as exemption clause, right? And basically, when there is an exemption clause, the party exempt himself from liabilities. The other party cannot get compensation when he suffer loss or injury, right? So when you park your car, park at your own what? Park at your own what? Park at your own risk. So this is exemption clause. You want to park, fine. You pay parking fee, but park at your own risk. So if anything happened to your car, the parties, okay, the authority that deal with the parking area refuse to take liability. And if something happened, you cannot sue them to get any compensation because they say park at your own risk. This is exemption clause. Yeah, this is an auto pay car park. I put a photo here, right? So these clauses, it can be printed in ticket on receipt, and sometimes very small, you can't even see it. But exemption clause basically exempt the person, the party, the authority from any liabilities, all right, from being sued for damages or compensation. Okay. And however, you see, the courts have nevertheless endeavored to alleviate the position of the recipient of such documents containing exemption clause by requiring certain standard of notice in respect of terms, by construing the contract wherever possible in favor of the recipient. So basically, court don't simply accept. The court will look at the situation and also look at the terms. Okay. So this is exemption clause, and most of the agreement, they do have this, all right? Agreements mean, you know what agreement means, right? So contract also, we have exemption clause. And you have to look at your own contract. Is there any exemption clause in PTPTN contract or no? Check. Right? Requirement of certain standard of notice. For contract, basically there's a requirement that when you sign a contract, the person, for example, lawyer and client, I was a lawyer before, it's my duty to go one by one. For each term, each clauses in the agreement, we go through one by one until the end. All the pages of the agreement, you see. If there are 50 pages, then I will go through with my client 50 pages and make sure the client understand and answer all the client question before the client make decision to sign the agreement. We don't simply ask, I never simply ask sign, no. We sit down and actually we make sure that they know what and what agreement they are signing, what kind of contract they are entering into. Okay. You see, because why? Because the moment you sign an agreement, right? Whatever contain contractual terms in there, you are bound by the agreement, right? You cannot later on say, look, I did not read, I just signed because my lawyer says so. No, you have to read. You have to make sure that your lawyer explain to you one by one. All right. That one with lawyer, and sometimes someone just give you a contract and ask you to sign, you simply sign, something happen later on, right? Something happen later on, you cannot say, look, you cannot simply defend yourself saying that I did not read, I was told to sign. The moment you sign something, you bound by the terms in the agreement, in the contract. Okay, even though you are ignorant of the legal effect. All of you are accounting students, business students, right? One day you will enter into contract, so you have to make sure that you understand every single clause, every single terms, and the effect of the terms, right? Now, but if the document is not signed, being merely delivered, then the question arises whether the terms of the contract were adequately brought to his notice. So, you got the agreement. They send the agreement through post to you and ask you to sign. So you have to call them and ask them, because there is a requirement for certain standard of notice. The person must have notice of what they are signing, right? The notice for exemption clause must be contemporaneous with the contract. It must go together with the contract. Okay. To make an exemption clause binding, it must be brought to the attention of the contracting party before or at the time the contract is made. Okay. You cannot ask the other party to sign the agreement, then only you brought into their attention. Cannot. In the Ole and Marlborough Court Limited case, plaintiff and her husband, they went to the defendant's hotel. They paid for a week. Once they have paid, which means they signed the agreement, they went to their room, and then they saw a notice on the wall, which says that the hotel will not take any responsible if the property of the guest being stolen or something happen. They will not take responsibility. Okay, it's the responsibility of the guest. right? Because of negligence of the hotel staff later on, a coincidence here, and then a thief gained access to the room and stole some of the plaintiff property. So now the plaintiff brought the matter to the court, right? And then the court in this case actually said that, you see, the notice actually part of the contract, okay? And the plaintiff could not have seen it until the contract was made. So in this case, the court said that the defendant supposed to bring the attention to of the plaintiff before the plaintiff signed the agreement. So defendant must tell. It must go together. After the plaintiff knows, if the plaintiff agreed to the exemption clause, then the plaintiff signed, then it's okay. The plaintiff will take responsibility. The plaintiff will let go the defendant liability. However, in this case, since the defendant didn't do that, okay, didn't do it together with the contract, so defendant were liable for the loss, okay. In Malaysia, we also have this one case, Go Hun and Yusof, I think brothers in Berhad, okay, which has the same effect with this case. And second, the notice must be reasonably sufficient, okay. In Parker and South Eastern Railway Company, right, the court in this case held that a person may be bound by an exemption clause in a standard form document if the party seeking to rely on the clause has done what was reasonably sufficient to bring it to his notice. So which means that the exemption clause will only be binding, all right, if it was brought to the attention of the party, all right, which means the party knows, after I signed this agreement, I entered into the contract, there were exemption clause, which means I exempt the other party from his liability. I will not make compensation. I cannot make a compensation because I exempt him from his liability. All right? And in this case, also the court, the issue, one of the issue was whether, how can we say that notice has been given or notice has been brought, which means how do we say that this exemption clause has been brought to the attention of the party, right? In this case, the court says that it depends on the fact of the case. Whether notice has been reasonably sufficient is a question of facts. So which means they have to look at the facts and see whether it has been brought to the attention of the party. Okay. And we have one more case, a Malaysian case. In Malaysian Airlines, Berhad and Malini Nathan and another. In this case, the respondents were booked and had confirmed ticket to fly on the Malaysian airline MAS on a scheduled date. However, the flight was fully booked, so the airline MAS was unable to accommodate the respondents on the said flight. And the respondents were not happy. The respondents sued the MAS for damages. However, the airlines, the MAS, rely on their the condition 9 of the condition 9 of the condition of contract printed on the airline ticket. The condition stated that carrier may, without notice, substitute alternate carrier or aircraft. Schedule are subject to change without notice. Carrier assume no responsibility for making connection. So which means in condition 9, MAS is stating its exemption clause. Okay, when the respondent purchased the ticket, respondent got the ticket, is stated behind the ticket, so it is assumed that the respondent has read all the terms. Okay, it is assumed that the respondent actually agreed to the exemption clause. So in this case, the court held that the airline was entitled to rely on the said condition and was thus not in breach of contract. So the court say, okay, that's no breach of contract. I think, all right, I think that's all. Thank you very much.